Hello everyone, I'm Sue Taylor and you are listening to a Sitting with Sue podcast. Today I'm delighted to have sitting with me Mark Gayler, a very experienced claimant catastrophic personal injury solicitor from Minster Law. Mark is recognised as having particular expertise in amputations, fatal accidents and serious orthopaedic injury claims. Firstly, Mark, a little bit of background information on your career and current role, and then we'll go straight into our first question.
Hi Sue, thanks for inviting me along today. I started working for Northern Star Insurance about 40 years ago in the motor claims department before moving to Amery Park Solicitors in Bristol, where I qualified. I then subsequently left them after about 18 years, went to two other firms in Birmingham, one of which I was a head of litigation. And then in 2011 moved to New Law, where I started to pick up the catastrophic injury work and in particular amputation work as a result of motorcycle accidents. 2.5 years ago I left and joined my current employers, Minster Law, firstly as an associate and now as a partner, dealing with mainly motorcycle accidents in a very large department with over 200 people and over 50 associate solicitors. We are the partners for numerous insurers and brokers as the trusted partner to deal with the personal injury claims of their customers.
That's really interesting. Mark, fairly obviously, reserving is essential because of insurers' liquidity requirements. But when it comes to catastrophe injuries, the variance in figures in the guidelines can be absolutely enormous. And why is that?
That really depends, is resultant from the way that the system works. It is an adversarial system, but we try as much as possible to work collaboratively with insurers. But at the end of the day, each of the parties involved will get their own expert evidence. That expert evidence is based upon their opinions, their experience, and they will come to a conclusion as to what's going to happen in the future. Those conclusions will be different. As a result of them being different, there will be different values put on things such as care or aids and equipment, or whether they can or can't work in the future. And that's why you get such a massive variation in the figures that are often put forward by claimant solicitors and the figures that are put forward by defendant solicitors. Neither are right, neither are wrong, but they are just different. So for an insurer who has to reserve the full value, which will include all the rehabilitation, all of the costs, all of the actual value of the claim, those figures can be massively different.
So how you as a claimant lawyer come up with the figures you present is very heavily based on what the expert evidence is that you are given and the experts' reports. And particularly, you allow for the potential long-term care and radical changes to the lifestyle. Is that correct?
Yes, each expert will be asked to effectively say, this is what's happened, these are the injuries that have been suffered, this is the treatment that the person has been receiving, and this is what we think is going to happen in the long term. For example, a good example would be someone, an amputee, a lower limb amputee, below knee, they will need prosthetics. Now, the prosthetics that they're provided with generally tend to be private because the NHS can't supply them. So it may be that the doctor or the consultant suggests that they need 3 or 4 prosthetics for different things. That may be what the expert says. In our case, the expert may say for the defendant, he only needs 2. And as some of the prosthetics cost £90,000, that's quite a significant difference. So we have to base the claim on our expert evidence and what they say will happen in the future. So it may be that at age 75, they deteriorate and they won't be able to use their prosthetic as much and they'll be in a wheelchair. They may be in a wheelchair more for the rest of their life. They may need commercial care in the latter stages of their life, but there will be difference of opinion. So we just take as the value, what our expert says will happen in the future, and the consequences of that in financial terms.
So in relation to the general damages, you're really looking at the recovery, both short term and then also the much longer term view as well, which could, as you say, take them to 75 or beyond.
Yeah, in all these cases, they're life-changing injuries. Technology hasn't yet developed that we can grow back a limb. So they are always going to require prosthetics until such time as they become too infirm to be able to use a prosthetic. So I'm sure, as you undoubtedly know, there's the Judicial Studies College guidelines for the assessment of general damages and personal injury cases, which is a bit of a mouthful. So we call them the JSC guidelines.
Yes.
They've been around now for about 15 years, and they give us a tariff, if you like, for every single type of injury you can think of that a person may suffer. And there are different levels of injury, so it will take into account the recovery to date, if there are going to be future problems, if there may be deterioration, and all those are put into a bundle with a value. And we have access to that. The defendants, solicitors, and insurers have access to that. And we will determine from all the evidence that we've gathered from our experts what bracket that the value of the claim is. And I have to say, over the last probably 10 years, it has been extremely rare for me to be in a completely different bracket to a defendant solicitor, because at the end of the day, the injuries are the injuries. And particularly with something like an amputation, there is a set bracket for a below knee amputation to one leg, below knee amputation to both leg, above knee amputation for one, above knee amputation for two. We're all going to be in that bracket. It's just where we sit in that bracket.
And the bracket can be quite big depending on where it is. And because of the size of the catastrophic injuries, then it can be quite a lot in monetary terms.
Yeah, below knee amputation to one leg is something around 150, 160,000 pounds. Personally, I think most of my clients will say that's not a lot of money. But obviously, the major value in these claims is the consequential loss of that limb.
And getting as a claimant lawyer, you'll often actually be visiting your clients and seeing the extent of their injuries, which I assume helps you to actually consider the special damages, such as the loss of earnings and the potential for the adaptation of the workplace or their homes or whatever. Some of these will actually have to have dramatic changes of career even. And how do you actually do that from a practical point of view of seeing the person in front of you and then relaying it back to the black and white of the paper?
I tend to go and see clients right at the outset. I will generally go and see them while they're still in hospital if they're severely injured, and then I will go to their homes. I will have a look around because I know from my experience that if somebody has severe injuries or multiple injuries, they're going to have problems. I look at where their bathing facilities are, where the toilet is. When they come home, they're probably going to be in a wheelchair. If there are no toileting facilities downstairs, that causes a problem. You look at the size of the rooms, the layout of the house. If you're in a wheelchair, you need a much bigger turning space. You need wider doorways. So I'll have a look at all that. And although we will get occupational therapists involved, I can get a pretty good idea from the outset if where they're living is going to be sufficient in the medium and long term. It almost certainly isn't going to be fine in the short term, but we are where we are and we have to deal with things at the outset. You also sometimes will go to their workplace and do the same sort of assessments at their workplace. It depends what type of work they're in. If they're in heavy manual labour, the chances are they may well be unable to go back to work, and we would have to look at vocational rehabilitation. But the major important thing is this: I can do the assessment, but I need the insurers to come along with me to work in a collaborative way so that we can do what as best we can as early as we can to get that person to the right treatment with the right people and to give them the support that they need, because they're very vulnerable. They are struggling. They'll be struggling physically, mentally, and probably financially. And it's really important that assessment is done as early as possible and that we get the collaborative approach with the insurers that will lead to a better outcome.
And that to me is always one of the things that strikes me, is that one of the major issues with catastrophic injury claims is the time it takes to go through the process and the stress and the trauma that whole process creates on top of what they're already suffering from. And I wonder, do you have any thoughts on how could insurers and claimant law firms actually work more collaboratively to deliver better claims outcomes for clients?
I think most insurers are fully aware that when you have a case like this and it's catastrophic, that there needs to be a collaborative approach. There needs to be an agreement to instruct a case manager to do an initial needs assessment. The Serious Injuries Guide, which Minster Law are signatories to, and a number of insurers are also signatories to, sets out a framework within which you work. I think that's an extremely good framework. It encourages early assessment with the initial needs assessment, rehabilitation, early assessment of liability, the availability of interim payments. All these things are things that cause my clients stress. These are things which, if not done properly, can extend the recovery period, can make their lives even more difficult than they are already. And so I think an understanding of where the client is, where they are, how life-changing this is for them and their family is something that really does need to be stressed and taken into account. The earlier you can get them to treatment, the better the treatment there is, the likelihood is they're going to get a much improved recovery, and that recovery is going to happen much sooner.
Have you got any examples that you can actually give?
Yeah, I've got a great example at the moment with a client who's 26 years old. He's a below knee amputee. I saw him in hospital, went and saw the house, did an assessment of both, spoke to the insurers and the solicitors immediately, got an agreement to instruct a case manager who did an initial needs assessment straight away, and he has been referred through the Zurich protocol to Dorset Orthopaedics, who are providing him with prosthetics input, physiotherapy, and he goes every month, 6 weeks, for 2 or 3 days, has intensive treatment, intensive rehabilitation. He has already partially returned to work within 9 months of the accident. He has a private prosthetic. He's about to embark upon microprocessor trials. He's been rock climbing. He's done snowboarding. He's going to take place in the running part of a triathlon this summer. And he's progressing brilliantly. He still has a long way to go. His residuum is still going to shrink. He still needs check sockets rather than a final socket. But at the end of the day, his progression, because we've worked in a collaborative way and because Zurich have agreed to fund the recommendations that Dorset have put forward, has been remarkable.
That's absolutely an incredible example. I do remember I've historically dealt with quite a few on the rehab side, but I've never had anybody snowboarding or rock climbing subsequently. That really is a fantastic example of early intervention. We've talked about case managers, you've talked about rehab. Is there anything else that you think that could come into that as well?
I think that the main message I would try to get across that any claim like this is really in 2 stages. The first stage is all about the rehabilitation. The first stage is all about the treatment. It's the support that the individual needs to make that improvement and to get to their end point, whatever that is, as early as possible. That has to be dealt with in a certain way, and that needs to be collaborative. If that is collaborative, if the recommendations are funded, if there is support through interim payments, that makes a huge difference to the individual and also the outcome. It also makes a huge difference to the insurers because at the end of the day, that person is going to be at their end point much sooner. The treatment's actually going to stop sooner, probably. You may need long-term treatment, but that's something else. Then you move into the area of gathering your evidence to value the claim. So, as I've said before, we'll gather evidence from experts. The defendants will gather evidence from experts. And again, generally in these cases, we go to a joint settlement meeting, which is a form of ADR. We have a discussion and we decide if we can settle the case at a sum that is acceptable to the client and is acceptable to the insurers. So, although it is by nature an adversarial process, I actually think it works so much better when it's a collaborative process.
Yes, I can understand entirely. Basically, negotiation is far better and mediation is far better than going at it sort of all guns blazing from both sides.
Yeah, and cheaper, probably.
Yes.
Doesn't take up valuable court resources, and we all know how difficult it is to get any date in any courts at the moment, and the delays that there are. The whole process is better. It's better for everybody.
And also the mental stress of somebody having to go to court, especially if their mental state may not be that perfect as it is, having gone through all the trauma and still going through the trauma that they are going through. It's just an added strain that is unnecessary.
Yeah, and I've never met a client who welcomes the idea of walking through a court door.
No. So what is the number one point you hope the listeners learn from our conversation today? If you've only can have one point.
The understanding that for the individual, this is life-changing. This is something they were never expecting. They were never hunting. And an understanding that this traumatic experience is something that they will live with for the rest of their life. And that allowing them to get the treatment they need and the treatment that is recommended and to fund that is so important at the end of the day and is likely to lead to a much better outcome for everyone. I think that if everybody understands that and acts with that in the back of their mind, A, will have much less litigation, B, it will be cheaper, and C, we'll be able to settle these cases sooner.
That's fantastic.
Not sure that was one thing, but anyway.
It wasn't one thing, but I'll forgive you. So, and finally, where can listeners contact you?
On the Minster Law website, www.minsterlaw.co.uk, or on my email, mark.gayler@minsterlaw.co.uk.
Thank you. That draws today's podcast to a close, and a huge thank you to Mark for joining me. And you've been really interesting and very informative. Please, if you want to contact Mark, just refer to the show notes. And for other podcasts, go to www.suetaylor.co.uk.